record button's on.
The record button's on. Okay, well, good morning, everybody. I'm Melissa Pache, the CEO of the Whistler Chamber of Commerce, and today is April 23rd, 2020. I'd like to first acknowledge that we are having this virtual meeting on the shared unceded traditional territories of the Squamish, Lillooet Nations, and we honor their language, culture, land, and traditions. I'd like to start by thanking all of our members for your continued support. The Chamber receives through your annual memberships, dues, and commitments enabling us to do the important work we do. Pat Kelly with Whistler Real Estate, as well as Sholto Shaw with Race & Co. certainly have been huge supporters of ours, partners of ours with the Whistler Experience, or with Whistler Excellence Awards, as well as the Women of Whistler for years. So thank you both for that. Today's topic is the sixth of a series of COVID-19 business support. We'll be sharing intel on how to navigate the current COVID-19 issues impacting parties to commercial lease. Whether it be questions on rent deferral versus abatement, operating costs, and the possible closure of premises. Find out what recommendations and strategies might work for you in dealing with these and other challenges you are facing during this time. I don't think my coffee's quite kicked in yet. Bear with me. The purpose of this series of webinars is to ensure that you, our members, and the broader business community of Whistler have the opportunity to have your most pressing questions answered by experts who will provide guidance and support for you to navigate these very challenging times. We are using Zoom, as you can see, and the Q&A, which is at the bottom of your screen. If you click on Q&A, that's where you'll be able to ask your most pressing questions. So go in there, simply type your question in. If you don't have a question, but you do like a question that's being asked, you can actually vote on it by hitting like, and it'll be upvote that particular question to the top. So today, we're honored to have with us, as I mentioned, Sholto Shaw, a lawyer with Race & Company, as well as Pat Kelly, president of Whistler Real Estate. Commercial rent is one of the hottest topics in not just our community in Whistler, but right across the nation. With May 1st just around the corner, both create new partnerships, new contracts. So with just May 1st coming up, it's going to be really crucial for us to have some very specific answers and direction on what our businesses need to do to move forward. In this discussion, it's important to understand that some landlords are small businesses as well and rely on the rent to support their families. So I think in this particular session, we'll be talking on both sides. As we eagerly await news of commercial rent relief from our governments, let's talk about what we know today and advise on how we can move forward. So to lead us through this discussion, I'd like to introduce to you our guests, Sholto. Sholto, this is your second webinar with us, so I welcome you back. Born and raised in London, Ontario, we won't hold you against that one, and has lived in 7 cities on 3 continents since leaving London to attend university. Sholto has practiced mainly in the areas of real estate, wills and estates, corporate and commercial law. Sholto is also an active member of Whistler's volunteer community, has also served as a director for the Whistler Chamber of Commerce, the Community Foundation of Whistler, and Aware. Also, welcome Pat Kelly. Pat has been active in the real estate business in Whistler and Pemberton since 1981. As a result of he has an unparalleled level of knowledge and experience in all aspects of local real estate markets, whether it's commercial transactions, residential resale, or new home project sales. Pat is a graduate of commerce program at the University of British Columbia and holds a master's degree in legal studies from Simon Fraser University. He's been the sole owner of the Whistler Real Estate Company since 1999. He is an active volunteer and takes part in as many recreational activities as his time and aging body allows. I didn't write that. Did you write that?
I did.
That's good. So, Sholto, what we'll do for this discussion today is, Sholto, we're going to start with yourself. If you could give us sort of an outline of where you're at as a lawyer, what you're hearing, what you're seeing, and then we're going to lead into the next part of that conversation with Pat doing the same thing, and then we'll open it up to Q&A. So, Sholto, do you want to start with us today? Oh, sorry, Sholto, did I say that? Sholto.
Yeah, thanks, Melissa. Right now, it's sort of quiet. I think we had a bunch of calls, panic calls initially when businesses got told to shut down or realized they had to shut down because there were no clients anymore. And businesses very worried about being able to pay the rent and frankly unable to pay the rent, talking about or asking us about what they should do in terms of just leaving, not paying the rent at all. How should they communicate with their landlords, if they should communicate with their landlords? Some of the landlords are very difficult to get in touch with because they're very, very large international commercial landlords and have pretty significant holdings. And so small Whistler businesses aren't a huge concern to them, at least initially when the pandemic hit, because all the landlords, I think, had phone calls and emails from clients or from tenants letting them know that they wouldn't be able to pay the rent, or how do we deal with this. That seems to have calmed down a little bit. I think landlord or tenants are now trying to figure out how they can stay in business, how they can make it work. People are pivoting. It's the common word to use to do something different. Restaurants are doing takeout. There's a lot more online shopping. So after that initial panic of calls to us about how do I break my lease, or what are the penalties for breaking my lease, I think a lot of businesses have decided maybe that they won't be breaking their lease, or they're going to try to hang on for a little while longer, because frankly, for a lot of our clients and for a lot of small business owners, the small business owners are personally on the hook for those leases as guarantors or indemnitors. So even if their business, who's the tenant on the lease, can't pay the rent and stops doing business, those people, the principals of the business, may still be on the hook to pay unpaid rent. And those people are looking at equity in their homes and their savings and their RSPs, possibly having to be paid to landlords. And so these tenants have decided, well, maybe we're going to have to try to stay in business so we don't lose not just our business, but also some of our savings or other equity that we have.
And one of the questions that's come up quite a bit is, can you explain the difference between a deferral and an abatement? Because some members may not understand what that means and what it would mean to their business, the difference between the two.
Right. So an abatement basically means a reduction in your rent, full stop. And it could be a percentage amount. It could be some other amount that the tenant and the landlord agree to. And so that's different than a deferral. And a deferral is simply postponing your obligation to pay rent. It's sort of like currently the banks are allowing mortgage deferrals to borrowers, and that's, you're still on the hook to pay the entire amount of the mortgage plus interest on the amount that you're not paying for this 4 or 6 month period. So for a lot of small business owners, a deferral after they've been closed for 6 months is maybe not possible, because it's pretty tough to dig yourself out of 6 months of zero revenue or significantly reduced revenue, and then still have to pay that 6 months of your full commercial rent, triple net, and probably interest if the landlord demands interest on that. So you often need a pretty seriously long time to pay back that 6 months of unpaid rent. An abatement, however, gives you a break on the rent for that 6 month period or 1 year period or whatever you need. So instead of paying $25,000 a month in rent, you'd be paying $18,000 or $15,000 or whatever you can handle and still stay in business. Or maybe the landlord and the tenant will negotiate some combination of the two, an abatement for a certain amount and then a deferral going forward after this sort of initial 3 month period.
Yeah, and that will depend on the contact that you have and the relationship that you have with your landlord and the situation that they're in as well.
Right, and there's almost certainly not any clause in your lease that contemplates this scenario. So it's going to be and there's no real law that dictates what happens here. It's simply a contract that the tenant and the landlord have, and they are at complete liberty to negotiate changes to that contract.
Right. That makes sense. Very much so. Pat, can we go to you then now for some comments? And we're starting to get some questions in. I certainly have a list of them myself, but Pat, do you have some comments that you'd like to share with some of the experiences that you've had in the last month and the questions that you've had and some of the concerns you've had and certainly some advice, which is I think what a lot of people would love to hear right now.
Well, I think Sholto covered the legal side of it exactly the way I would have described it. I think it's important to remember that every lease situation is individual to the parties involved. And your lease will determine what you can and can't do. I think some of the anecdotal information I'm hearing is that, as Sholto said, some of the smaller landlords are being, I would suggest, more proactive and more flexible when it comes to either deferring or doing abatement. Typically, it's one of the two, but the triple net expenses are expected to be paid, which are no small item in this town. It's certainly $25 to $30 a foot, which is triple net just about everywhere except function. And people are sitting down, and I think one of the key things that I've heard is that you have to be prepared to be very transparent about your situation, not only currently, and that includes both your business financial situation, but your personal financial situation, and also be prepared to discuss how you're going to work out of it in the longer term. All the government assistance and abatement or deferral that can be achieved is going to be a short-term issue. And in the longer run, your ability to pay rent or make up deferred rent is going to be a function of how you see the world going over the next 8 months to 20 months, depending on what your opinion is of how long the economic impact of this event is going to take. Which means doing some serious thinking about whether your business is going to be in a position to generate revenue and how much revenue over the next 6 to 10 month period. And that may mean pivoting a little bit on what you're offering to your consumer. Who's your consumer going to be? I know the Destination BC and Tourism Whistler are very focused on generating business from British Columbians as compared to the destination tourist who we've relied on for probably 3 or 4 years. There are options out there that are worth discussing if you don't think that you're going to be able to do what you have done in the past and you need to get out of your lease. The legal ramifications, Sholto can certainly educate you on it, but most leases do allow for some ability to assign the lease or sublet the lease in whole or in part with the approval of the landlord. And if that's an option that you feel you need to take, it's worth to sit down with the landlord and talk about how that could be dealt with. I think the other thing to be aware of is that there is no shortage of interest in owning lease or retail space or operating a retail business in Whistler. Yes, it's a little uncertain right now, but there are spaces that are being shown. There are inquiries coming from people saying, is there space available in function? Is there space available in the village? There's a reason why there is no vacancy per se in Whistler, and that's because there's always been a fair amount of pent-up demand. So there are solutions out there if that's the direction you want to go.
Right. I do have some questions. I see one question up there, and I'll hold on to that question for just a moment. What rights, and this probably will go to Sholto, what rights does a business owner or tenant have if the landlord doesn't agree to rent deferral or abatement? So I've heard, and I don't know who, but I have heard that some tenants will not pay or have decided to pay a certain amount. What rights do they have right now? Because I know we're waiting for the government both governments to come up with a solution on commercial rent support. That I was really hoping that was going to happen this morning. In fact, I texted Patrick Weiler to see if there was something, and I haven't yet heard back from him, but that hasn't been said yet. I just wondered again, what rights does a business owner or tenant have if the landlord doesn't agree to a rent deferral or abatement at this point? Do they have any rights whatsoever?
Generally, like Pat said, every lease is different, and the relationship between the landlord and tenant are different. Generally, there's a legislation that dictates in sort of general terms what landlords can and can't do in terms of a lease, but generally the tenant doesn't really have much in the way of rights. It's a contract that the tenant signed with the landlord, and that's the contract. If they break the contract, which typically for the tenant just means you are open for business and you pay rent. If you don't pay rent, typically leases allow landlords to evict the tenant essentially without notice. And that's what the landlord can do. Now, that's pending government intervention, which has happened in Australia. The Australian government has said, kind of like the British Columbia government has said, no residential evictions. Right now, there's a moratorium on that. I suspect something like that's going to come along in British Columbia and in Canada. I know the governments here are working. The First Ministers were meeting last week, I think, about that very issue and trying to come up with some sort of essentially protection for commercial tenants to allow them to try to change how they do business or come out of being closed without being evicted right away. As far as I know, that hasn't happened yet. So, up till now and what's happened in the past, if the landlords decided that they wanted to get rid of that tenant, they're within their rights to do that. As long as they do it according to the lease and according to the law, they're allowed to get rid of that tenant. And, it may be that your landlord, if you're a tenant, has been waiting for an opportunity for you to stumble in some way, not pay rent, breach the lease in some way so that they have an opportunity to kick the tenant out and get in a new tenant that they've been negotiating with, that they want more than they want their current tenant.
Right. Okay. What are some commercial landlords doing to offset the burden on tenants? Pat, have you heard anything around that yet?
There's a new term going around in our industry called price discovery, and at this point, other than what I've already referenced, which has been either some deferral of rent or abatement of rent, even as far as one situation I heard about down to nothing, other than triple net expenses. I haven't heard of anything else. Again, I think this is a very dynamic kind of situation, and it is where you believe that you are a valuable tenant. It's worth being very proactive with your landlord to sit down and discuss a longer term solution if you think that's warranted. I think there's as many opinions about what the future holds for us as there are people speaking about it. And, not surprisingly, human nature is to always hope for the best and that we'll get back to normal within 2 months. That may not, in fact, be the case. And, there may be, over the long run, some rolling adjustment in things that could be dealt with proactively. But I think we need to actually see that happen before anybody is going to jump on and say, well, that's what we have to do. That's the new reality. And I think we haven't yet determined what the framework for reality actually is going to be going forward.
Right. Makes sense. The question we have up on the screen right now is, do you think, and could either one of you answer this, do you think legislation would change regarding personally identifying the lease with the case of COVID-19?
Well, I think right now, like Pat said, everything's dynamic. What we are talking about right now is how things have been in commercial leasing for the past, 30 years in British Columbia. Just like employment law, this pandemic has kind of changed the playing field so that past practice and past case law and past precedents may not govern how courts treat employment relationships, commercial leasing relationships going forward. And, there's no guarantee as a landlord that if you decide to evict a tenant, or a tenant, if you, just simply don't pay, that the same remedies the same remedies that courts used to give to landlords or tenants will stand up going forward in 2 or 3 or 4 years when cases that arose from commercial leasing breaches, contract breaches today, actually make it in front of a judge 3 or 4 years from now, I mean, people's opinions may completely change. And so I think whatever you're doing, whether you're an employer, whether you're looking as a commercial tenant or a commercial landlord, you have to be really reasonable in what you're doing. Probably talk to a lawyer, talk to your landlord, talk to your realtor, whoever it is, talk to your accountant about, making a case for whatever it is you want to do, and making sure at least you're making whatever decision it is based on something, and not just a gut reaction, or not just what's happened in the past with commercial leasing law, because that might not be what happens going forward. And we're not going to know what it is. There's, nothing's going to get before the courts for a couple of years here. So, you may come up with some novel argument of, frustration of the contract or whatever it is, but until if your landlord decides to terminate your lease, and you need to, you come up with this novel argument about why you were allowed to terminate the lease, you're probably not going to get any resolution to this for a couple of years. And who knows if that argument's going to, win any favor, or, get you a positive judgment down the road.
Yeah, that makes sense. Where am I? Oh, a question I had sent to me a little while ago from a member was, since March 10th, there's been zero revenue with 4 years left on their lease, with no revenue until they can prepare and open up. What options do they have? I guess from what I'm hearing, if no revenue is coming in, and tourism, obviously this person is heavily reliant on tourism and meetings and conferences coming to town. It sounds to me like the only option is to forfeit on a lease. Is that what I'm hearing, or are there other ways to go?
Practically speaking, I would say you have sort of 3 options that need to be investigated. First of all, read your lease,
right?
Find out what you can and can't do, and then obviously approaching the landlord to be released from your lease. He may have a tenant he's prepared to put in there, or he may call someone like myself or one of our agents and say, have you got a tenant for this particular spot? And there may well be an easy solution. You may be allowed to assign the lease to another party. If you know somebody that's ready to step in, you may be able to sublet it, which basically the difference being you'd still be on the hook for the rent, but at least you're going to have some of it offset. You'd be an indemnifier for whoever your subtenant is, and they take on your existing lease. Generally speaking, both those options require the approval of the landlord. There aren't very many leases out there where the landlord doesn't get to approve whoever occupies the space. They may also be prepared to let you sublet a portion of the space and bring another business in there. And we know with the gig economy that there's lots of people looking for desks and internet service. And you may find some way to minimize your exposure to rent until such time as we're allowed to have more than 50 people join together to have a meeting. So I think there are options. I don't think it's as draconian as you might think it is, but you do have to sit down and have a plan. It's time to, we had a saying in our office recently, it's, calm down, sit down, plan, and then act.
Right.
And I think you do have to think it through, and you may have to pivot your business a little bit into something new if you think you can. Otherwise, there are alternatives out there.
And I think I can't agree with you more. I think when you react to a situation too quickly, you're not thinking logically, you're not thinking long-term, you're thinking immediate. And for many, that makes sense. We as a chamber had to make some immediate decisions on what we were going to do with our staff, with our business, with our model. And now we're starting to, again, look at how we make those changes to ensure that we stay, top of mind, we're influential, we keep the ball rolling. So we're no different than any other small business out there. So I really appreciate what you're saying and how you're leading your team. So well done on that one. A question on there was, how do subtenants stand? Or I guess, where do subtenants stand? The subtenants landlord default on their head lease. Or if, can't read this, or if this subtenant's landlord doesn't open their venue, then where does the tenant stand? Really hard to read that question. So if you can, I'm not sure if there's a question in there, but I think you've also talked about subtenants already and how that might stand for in the.
Well, again, it's a bit complicated, and basically you are the tenant and you have the landlord's approval to have another business. Typically, when you sign a lease, you are required to operate a particular type of business. You don't operate that particular type of business, you are technically in breach. I think Sholto would agree with that. You can't go from being a retail store to a cannabis dispensary without the approval of the landlord. So if you're going to bring in somebody else to share your space with you, the landlord needs to approve that. You will still be obligated to pay the rent, but your responsibility is to collect that rent from the other tenant. But at the end of the day, the landlord has to approve all of that. You can't just do it and hope for the best.
And is the head tenant, as a second question there, as the head tenant, are they the ones that are most responsible for that lease as a subtenant?
Absolutely.
Okay.
Yeah. Unless you assign the lease and the landlord agrees to allow somebody else to assume the terms and conditions of an existing lease, and he may still want you on as an indemnifier, but as the head tenant, you are responsible for making the rent payments. You're just hoping to find somebody, not unlike sharing a house residentially. There's usually one person signs the residential lease and then he goes and collects from all the roommates and gives it to the landlord.
Right.
Now, if your landlord, or if you're a tenant or subtenant, if your landlord shuts the premises down, I'd argue that you don't have to pay rent because the contract was for your landlord to supply you with premises for you to operate in. If they've essentially taken the premises away from you, either because they've been forced to shut down or for some reason they've decided to shut down because they've got a bigger venue that they operate in themselves and you're just a small portion of that and they've had to close, I think that your rent would be abated probably 100% for the period that they're shut down. I don't think the lease would necessarily automatically be terminated, but I would think that you would have the ability to not pay rent and probably not pay triple net during the time that the landlord shut the premises down.
Right.
Your business interruption insurance may cover that sort of thing. It may not. So that's something to check with your insurer about. But again, and you may have a damages claim against the landlord if they've shut down other than by government order. Again, that's something that you're not going to know with any certainty about until 3 years from now, by the time you get in front of a judge or somebody else has gotten in front of a judge on the same question and that matter's been sort of settled. But it's not going to be anytime soon. So like I said before, you should act as reasonably as you can and with as much advice as you can and try to work out a deal with whoever it is you're dealing with.
Great information. Pat, we all had a discussion about 2 days ago before this meeting, just to prepare for this meeting. And one of the things that you had said was you had talked about some really good suggestions on best practices during the lease renewal time. Can you remind me of what I'm putting you on the spot?
Oh, okay.
But I know one of the other things that you had said was when you do, if you are renegotiating or negotiated any changes, to have it in writing on both sides.
Yeah. Well, first and foremost, anything you agree to has to be must be in writing, and you should have the background information that supports whatever eventual agreement you make. I think I would, if I was negotiating a new lease, I certainly would want to take a look at my renewals and how many renewals I have, what my arbitration clauses are. I want to be very clear on when I have to give notice on renewal. One of the things I do see coming up time and time again is that the tenant either isn't aware or forgets when he has to renew his lease by. And the problem with that is if you don't give notice to renew by a certain date, then you lose your rights of arbitration, and which means that you are essentially negotiating to stay on past when you thought you were going to stay on. So that's a very key date. I think the other thing is I'm not sure how many, certainly some businesses do, some businesses don't. but it's important to read all 25 pages or 32 pages of that lease and understand what they say. Things like force majeure, that's a question that's come up a little bit. You know, can't I not pay my rent because of force majeure? Well, the problem is some leases don't have a force majeure clause, some do. And there is some legal opinion as to whether force majeure includes a pandemic. I think one of the things we'll see going forward, as Sholto said in new leases, is you may very well see a pandemic clause or pandemic included in force majeure. So you have to sort of think forward beyond just your business plan. And if you are going to change your change or pivot your business at some point over the term of your lease, you want to have the ability to do that. And a lot of that is just communication. A lot of it is sitting down with your landlord. And as I say, I've found the majority of landlords in this town to be more than willing to sit down and have a discussion, and that they are objective and they are not unaware of the situation. The larger landlords in town here, as Sholto said, I mean, they are dealing with hundreds of thousands of feet of tenants who are in exactly the same situation as your 1,100 square foot store. I mean, we're hearing things like Earl's not paying their rent in Vancouver. We're hearing other major national brands just basically saying we're not going to pay the rent May 1st. So the other little saying that's important to keep in mind is that when the sky is falling, it lands on everybody's head.
Right.
And, you know, they are battling with their own issues as well. And they have staff, they have mortgages, they have costs that they need to deal with as well. So you need to work out a win-win solution, not one that's simply in favor of you. The landlord has to be acknowledged that they have a position in any negotiation.
Good points. There's a question on the Q&A. There has been a lot of chatter about what the government will bring to the table for commercial rent relief. And again, I was hoping that would come out today. Waiting. Do any of us know if what is being discussed will apply if the landlord is a foreign investor? I know that the SEBA, were required to have a business account in Canadian banks. So true. I don't have an answer to that. I would think that maybe Patrick Weiler might, once we understand what that commercial rent relief might look like. Do you have any insight into that? Do you have that crystal ball? You don't? I wish you did.
I mean, all I would suggest is it won't be for very long.
No.
You know, whatever relief that comes forward won't be for very long. I'm surprised that you could be a foreign landlord without a business account in this country. It would seem to me if you're generating income, you have to be paying tax. So how you would be not doing that is a scratch. I guess if you're asking if you're a foreign owner, would government assistance be available to you? And the way it's been laid out to me by my accountants is whatever assistance will go to the landlord as expected, it'll be passed through the tenant. But it'll be a deferral. Right?
Yeah.
It'll be some combination of deferral and abatement, just like the SEBA was, and payroll. And there will be a time limit on it. It's not going to last for as long as whatever the fallout from this is going to last.
So it's really about being innovative.
I think what all these programs are doing is buying us a couple of months to sit down, plan, and act, and to think about how we're going to come out of it. That's what it's buying you. It's not buying you a get out of jail free card. Right.
No, well said. Sholto, do you have any comments on
that? No, my understanding was that they were really looking hard at the Australian model of this commercial rent support, which included the government and included the banks, because the banks are probably ultimately the ones who the landlords are worried about pleasing, and that the landlords almost certainly have mortgages that they have to pay. And so you're not going to get a lot of sympathy for your landlord if they've got a mortgage to pay. So my understanding is the federal government's looking at the Bank Act and figuring out some way to compel the banks to accept abatements, deferrals, or some combination thereof, so that everything doesn't fall, ultimately on the tenant and the landlord to absorb this, that the banks, who are arguably well placed to absorb some costs, are part of the solution also. And it's not just government, landlords and tenants, that the banks are involved too. because they're making money off of the mortgages that they've lent on.
Yeah,
My sources tell me that at this point, the banks are not being particularly flexible on their attitude towards deferral, and that's about it.
I'm just looking at all our attendees that are on the call today, and I can say that a vast majority of them are definitely the restaurant industry in Whistler. I can see, I don't want to, I'll call you out, but Kevin Wallace is on the line as well. And I know that he runs an incredibly efficient business up here with Earls. And I just want to make mention that it's not Earls Whistler, but it's
No.
Earls. I just want to make sure that that's clear, just because you just got to be making, don't want to spread any rumors right now.
No. I mean, it just, the point being is that there are some very big major tenants. I mean, if you own the Pacific Center and everything's boarded up, you've got some fairly large problems in front of you,
Right.
that are probably occupying more of your attention than your space up here. The F&B business is one of those businesses that I think really is going to have, you know, depending on what social distancing looks like it going forward, that's going to be, there's going to be some dynamic evolution in that situation for sure.
So true, so true. Are there, maybe Sholto, you might have an answer to this one. Are there established BC government policies on protecting commercial leases, tenants, from being evicted? I think we probably did answer that a little bit, but more specifically in the way that there's protection the same way the residential is. And I think we kind of answered that one in terms of there is no protection because it is a lease. It is
right.
A lease back.
Yeah, that's right. The Residential Tenancy Act is, you know, pretty, in my view, fairly tenant friendly, and with good reason based on some landlords, residential landlords' past conduct. There are general provisions. You know, there's a Commercial Leasing Act. There are certain things landlords are allowed to do but not allowed to do. You know, there's implied terms of leases. You know, in that the landlords have to be reasonable, for example. Landlords can't necessarily just swoop in and grab all the tenants' stuff out of their business and take it off and sell it, you know, at whatever price they want to, whenever they want to. So there are generally certain protections, but, you know, ultimately, if you, you know, the fundamental obligation of a tenant under the lease is to pay the rent. And even if there is a force majeure clause in your lease, which, you know, like Pat said, it's fairly rare, there are force majeure clauses in some leases. Typically, though, those, and so what I'm saying is don't get too excited if you see that in your lease, because typically those hive out from the force majeure clause the tenant's obligation to pay rent. So even if there is a force majeure clause, typically it's, you know, the landlord being prevented to do something they're supposed to do under the lease because of, you know, acts of God or strikes or whatever. The landlord's not obligated to do certain things that they may have to do under the lease, like provide utilities or even provide the premises necessarily for a short period of time if there are strikes or lockouts or, you know, a tornado or whatever it is. Right. You're still obligated to, when that situation has resolved itself, you're still obligated to be the tenant and to pay the rent. But you are, despite that force majeure clause, you're still obligated to pay rent. So if your financial circumstances don't allow you to pay the rent, that's not the landlord's problem, and that doesn't typically fall under the force majeure clause. So no matter what's going on in the world, this force majeure clause typically says whatever's going on, the tenant still has to pay rent.
Right. I think one of the things I'm seeing again with some of the people that are on this call right now, we call it the community of practice. And what we've been doing is utilizing the facilitators and honoring them and their best practices to share with our members. And I know there's some people on the call, members on the call right now that have had great success in writing letters to their landlords. What I would encourage those of you that are on the call that have not had success or that really are stuck in understanding how best to communicate with your landlords, I would highly recommend, I'm going to put you out there, but talk to Pat, talk to Sholto, reach out to the chamber, and we can certainly help in understanding what your needs are. We could even create a template, but we need to know what it is that you're looking for us to be able to support you. Kevin Wallace has a question up. So, hi panelists. Earls has found workability with about 90% of our landlords across Canada for temporary workability. The other 10% is mostly waiting to hear more on the details of the government program still to come. Thanks, Kevin, for letting us know that. That's good intel to have, and I think you know, that's what we're all waiting for at this point. So,
and you know, that's what's happening up here. 90% of the landlords are not being obtuse and being difficult. They recognize that there's something to be dealt with here, and depending on their situation, they will try to work things out. But I do think the communication and transparency is very, very key right now, and also communication and transparency about how you see yourself moving forward. Because, you know, no landlord, if we're just deferring an ultimate situation by 2 months, that's probably, you know, best to make the decision now, and move on and do it in a friendly and happy manner as compared to a confrontational one. Because as Sholto says, the process, if you go to the maps with the lawyers, is expensive and it's going to take a long time.
No, you're absolutely right. Pepe is on the line, and it's more of a comment, but thank you all to the panelists for their time. This conversation has been valuable and informative to better understand the rights and responsibilities. Thank you, Pepe. And Pepe has been a huge supporter of sharing his intel, and he does have a larger team and same with some of the larger hotels on the HR side, they're willing and able to share some of their best practices. So we'll, as a chamber, start to collect more and more of that. But again, like I said, make sure that you're communicating to us what your needs are, so we know what to provide for you. There's a question that just came up. What do you feel is fair, abatement or deferral, or the combination? What have you been hearing is happening? And
I don't. Fair is a tough question. Fair is what works for both parties. It either can be a win-win, or it can a lose where both parties are unhappy. But you know, what I'm hearing is some combination of the two. Usually abatement for a couple of months, but pay the triple net, or deferral for a few months. The key one seems to be triple net in most cases. Is that's the one that the landlords really want to see get paid, which makes sense. Those are the operating expenses, property taxes, condo fees, things that you can't really defer at all. And I think, you know, I think it's situational. I don't think I want to take a position as recommending which one you would go for. I think you need to have a complete playbook of possibilities when you sit down with your landlord and say, well, I could do this or I could do that. You know, what works for you? How can we make this go together? And maybe it's start with an abatement, as Sholto said, start with an abatement for a couple of months and then go to deferral. But then if you're going to go to deferral, you're going to probably have to show how you're going to make good on that deferral at a later time. I understand most of the bigger tenants in the country, what they're working with is deferrals, because of course they know their cash flows are going to come back at some point in the future, and they've basically said to landlords, you know, we're good for this, just give us a break here for a couple of months. So it will depend on your situation, which is, I go back to the transparency discussion. Show what your resources are, show what your plan is going forward. How are you, if we defer rent, how am I going to get that rent down the road? Because it's still owed unless abatement occurs.
Yeah, what I found interesting, again, working with some of our members quite closely, James Reddy with Escape Route has done exactly that. He's being very transparent, from my understanding. I hope he doesn't mind me sharing this, but he's being very transparent with his landlord. He's kept his business as open as possible to show the landlord that this is what we're doing. This is all we can do right now. We're doing everything we can to recoup some of our lost earnings by doing what he's doing. So it's a great example of someone who is trying to make ends meet. We're kind of running out of time right now, but there's no more questions on the screen. What I'd like to leave our audience with is perhaps for both of you, last comments on what is one thing you would recommend to a leaseholder and one thing that you would recommend to a landlord, short and sweet. Pat, do you want to start?
To a landlord, listen. And to a tenant, review your business plan. Yeah, I mean, the word we're using around here right now is just survive. And so part of survival is, what am I going to do tomorrow? What am I going to do next week? I don't think we're not worrying about what to do 2 years from now. As a business operator, we're worried about what are we going to do this month? And let's focus on that, because that's what's important.
Great, thank you. And Sholto, same questions for you.
I'd say probably for both parties, don't make rash decisions. Whatever decisions make sure they're based on as much of reality as you can figure out at this point. Be reasonable with each other, because if you get into litigation with your tenant or your landlord, it's almost certainly going to be very expensive, and it will drag on for a long time. And all bets are off to some extent in terms of what the result's going to be, because what was the status quo a year ago, or 6 months ago, or I guess 3 months ago, may not. Yesterday, things are totally different. So I wouldn't rely on what's happened in the past to dictate how to move forward here. And I would say recognize that everything's dynamic, and like Pat said, if the sky's falling on you, it's falling on your landlord and everybody else. So just think about that when you're negotiating with your landlord and your tenant and your employees.
Great, thank you for that. The Chamber did release and send out a letter to Minister James on Friday, and one of the key points that we would like urgently requested the government was for the commercial rent support, and that the BC government does the same by supporting what the federal government is doing. I haven't heard anything back yet, but I know Patrick and Jordan are both on the same page with that. So let's just hope that the next few days we're going to hear something from the federal and then from the BC government. So in closing, thank you again, both of you, huge supporters of the Chamber. Can't tell you how much we appreciate your time, your support, your knowledge, and for being here again with us today. So thank you for that. We are recording these webinars and loading them onto our Chamber's website, so you can go back to them anytime. Go to whistlerchamber.com and you'll be able to find this webinar along with other helpful tools and resources on COVID-19 webpage. We'll continue to stay connected with all of you through our regular e-news updates, which come out on Mondays, Wednesdays, and Fridays, or more if need be. If you're not registered to receive our newsletters, if you haven't been receiving any of them, whether you're a member or non, you can go to the bottom of the main page of the website, whistlerchamber.com, and register your email there. And then lastly, but just stay healthy, stay safe, and reach out to your Chamber. We're here to support you. We need to hear your voice, and we are listening. So with that, we're going to be coming up with more webinars. Check tomorrow's, what day is it today? Thursday. I'm losing track of dates. But check our e-news coming out tomorrow for upcoming events and information. So on that note, thank you so much for your time, and everybody out there, stay safe. Take care, everybody.
Thanks, Melissa.
See you, Pat.